Hello and welcome to our webinar today. Thank you for joining us. My name is Eric Hauge. I'm the Executive Director at Homeline, and you are joined to one of Homeline's Wednesday webinars focused on Minnesota's eviction moratorium phase-out. Today is Wednesday, September 29th, and we're getting started at 1:30 here. We have until 3. And we'll be covering a brief overview of the eviction moratorium phase-out as we're joined by Homeline's Managing Attorney and Hotline Director Mike Vra, as well as Homeline's COVID-19 Eviction Response Coordinator and Housing Attorney Rachel Sterling. And then we'll also be joined today, we're excited to have special guest speaker Melissa Houghtaling, Housing Court Referee in Hennepin County of the 4th Judicial District. Who'll be sharing a little bit about what's going on in Hennepin County's housing court as cases are filed under the eviction moratorium phase-out law. So we'll get to our speakers in just a moment here, just a couple of logistical pieces of information. Again, just a reminder about what Homeline is. We're a statewide nonprofit organization. Our main program is a free and confidential hotline that any renter in the state can call and get advice about their rental situation. And we advise clients in English, Spanish, Somali, and Hmong languages. There's our contact information. Again, on these Wednesday webinars that are free and open to the public, we provide general legal advice about a variety of topics, including the phase out, but other Q&A on tenant landlord topics. But renters who have specific questions about their situation, we really want you to contact us directly so we can advise you. So please reach out to our hotline. The information's on your screen. You can also email an attorney on our website. And I'll throw these links in the chat as well, but I think folks who are joining us have visited our website to know that we have a variety of resources about the eviction moratorium phase-out law, timeline, FAQ, as well as links to our previous sessions and our upcoming sessions, which again, today we have 4th Judicial District Court Referee Melissa Houghtaling on with us. Next Wednesday, October 6th in the afternoon, we will be joined by Dan Hilton, who is a research manager at Housing Link. And he's going to be sharing a little bit about some of the research and data analysis that they're doing on trends in the rental market during the pandemic. We had Dan on at some point last summer or fall, and it was a very interesting session. So that's next week, and you can register on our website. Again, of course, on the 13th of October, 2 weeks from now, that's just the day after October 12th, of course, which is phase 5, when phase 5 of the eviction moratorium phase out begins. So we'll be focused quite a bit on that change in the law. And then just again, another reminder of the kind of the key rental assistance programs that we're referring tenants to and encouraging folks to get the word out about. The Rent Help MN website, renthelpmn.org, or you can dial 211. It's a statewide program for tenants to initiate an application for COVID-19 rental assistance. In Hennepin, Ramsey, and Dakota counties, you can access, landlords can initiate applications through the Zero Balance Project. And again, that's just in Dakota, Hennepin, and Ramsey counties. And then there's a specific direct application process through Ramsey County that tenants can apply. If you're living in St. Paul or the rest of Ramsey County, you can go straight through this program to apply. So with that, what we're going to first do is have Managing Attorney Mike Vra go through some phase-out highlights, and then we'll pass it on to the referee. We did get a good number of questions in advance, so we will be tackling questions, and some of them are directed about the court process, so we're hoping the referee can handle some. But throughout the, we should have some time throughout the and towards the end of today's session. So please, we prefer if you can send your question in via the Q&A button over Zoom so we can keep them organized. But feel free to send them in if you have questions about the content or questions of the referee later. So with that, I'll hand it over to Mike.
Thanks, Eric. And yes, we will be prioritizing questions for the referee today. The questions that are for her will go first, and the sort of the standard questions that we typically get will be dealt with afterwards if there is remaining time. But since we have such an important guest today, we'll be starting the questions with her once we're done with our introductory remarks, both from me and from the referee. So let's get started. This is our 65th version of this type of speech, I believe. And here we are talking still about when will Minnesota evictions be filed again. So as almost all of you know, evictions have been filed throughout the pandemic to some degree. But what we're talking about is sort of returning to what used to be before the peacetime emergency, the eviction moratoriums were in place. And the real question isn't when will Minnesota evictions be filed, it's when will sort of traditional non-payment of rent evictions be filed, because that is almost every eviction in Minnesota, at least it has been historically, when over 90% of evictions typically in a non-pandemic year were for non-payment of rent. And so that's what we're trying to figure out, is when that will recur. When will we get back to that original place that we were at? As we all know, we had peacetime emergencies in place for about a year and a third that banned most evictions from being filed. That peacetime emergency declaration power that the governor had was relinquished in exchange for a pretty decent sized compromise at the state legislature that had a lot of components to it. And one of them was an eviction moratorium off-ramp, or phase out as it's referred to. And that is where we're at right now. We are in the phase out process of the eviction moratorium. Why don't you go ahead and take us to the next slide, Eric, and we'll see where we are in our chart of phasing out, and just go to the shaded part as we typically do. Thank you very much. So where we are now is what we have termed phase 4. The actual law doesn't refer to them in this way, but we just found it easier to talk to people using these gradations. And the easiest way to understand what's been going on as we look at all these phases is that landlords are reaccumulating rights that they typically had before the pandemic began. And I say landlords are reaccumulating rights because almost all the rights that were taken away, if rights were taken away, were the ones taken away from landlords who traditionally had the right to file evictions against tenants. The old rule was, hey, look, if a tenant is a day behind in rent's due on the 1st, on the 2nd, the landlord could go file an eviction. That's how, if you want to look at it that way, pro-landlord the eviction statute was, at least on how soon they could file in Minnesota. And we're wondering, when will we get back to that sort of setting that we had in place prior to the pandemic? And so landlords have been reaccumulating these rights. So the rights that they obtained in phase 1, starting June 30th, they don't lose them when we go to phase 2 or phase 3. They stack on top of each other. The landlords are reaccumulating rights that they had prior to the pandemic. And so we are now in phase 4 is where we are at. And the phase 4 importance, we'll talk about whether it's mattered at all for a number of evictions being filed in a little bit. But what a landlord is now allowed to do that they weren't allowed to do prior to September 12th is they can file an eviction against a tenant who is behind in rent and is ineligible for COVID-19 emergency rental assistance. And so that is a significant phase. It really is. I've always said that phase 3, the one that was in August, was among the least important phases of the 6 that we have on the screen here. But phase 4 is an important one. Landlords now have the right to file an eviction for non-payment. Again, that's 90% plus of evictions is for non-payment of rent. Landlords have the right to file an eviction for non-payment if the tenant is ineligible for this rental assistance. Another big phase coming up is in, well, it's a couple weeks now, phase 5, October 12th. At this point, well, landlords pretty much have all the rights back that they had prior to the pandemic, except for the fact that a landlord can't file an eviction or proceed with an eviction if the tenant, the reason for the eviction is non-payment of rent, so the tenant's behind on rent, but the tenant has a pending application with rent help or one of the emergency rental assistance programs. And that stays in place through June of 2022. Now, I know that not everybody has joined us for all these sessions. We have a decent turnout today. So maybe this is something that you haven't heard before, but that's not a typo. It's June of next year that pending application safe harbor protection remains in place for tenants. And that is largely because when this agreement was reached, which was in the late stages of June, is when these things were being kind of negotiated back and forth between both parties, both the Republican and the Democrat Party at the highest levels of state government. They planned on giving people this much time for a couple different reasons, I think. I wasn't in the room, so I don't know exactly what these legislators were basing their decisions on. But one of the things that they looked at was, hey, look, rent help takes time. It's still not fast enough by almost any account. We want the money to get out quicker to landlords, so landlords are paid, tenants are caught up, and the money's spent down, this federal money that is filtered through each state. So we knew that rent help was slow when this was passed in June, but we also knew that there was a giant pot of money, and we wanted to make sure landlords got paid. That was a real impetus behind giving landlords this much time. Tenants wanted to be made whole. We want to make sure landlords get paid. And if rent help is going to take time, we need to make sure that there's enough time for tenants to actually make sure they go through the system, qualify for the money, and get landlords current on the rent and tenants caught up. So that is not a typo. It's June of 2022 is how long the pending application safe harbor lasts until. In fact, let's go to talk about the safe harbor a little bit more. Take us to the next slide, Eric. Thank you. Oh, I'm sorry. We're on the notice requirement. Yeah. The notice requirement is, well, it's of dying importance at this point. Today is the 29th, which means, yeah, 15-day notice. The math doesn't really add up right now. So this has been in place since the beginning of our off-ramp. And what it said was that if a landlord wanted to file a non-payment of rent eviction, and they've been able to for a variety of reasons since the pandemic off-ramp began, the landlord had to give a 15-day notice first, and it had to have some key components in it. It needed to say, hey, the eviction moratorium is over. I have the right to be filing an eviction now, which a lot of tenants have been hearing for months and almost, well, years actually, year and a half, that a landlord couldn't file an eviction. So this notice had to be saying, I can file an eviction. It also needed to state how much rent was due and include some information about where the tenant should go to get rental assistance. As mentioned, this is important until October 12th, at which point its importance is done. It has no relevance after October 12th. The 15-day notice is no longer required from a landlord in order to file the non-payment of rent eviction if a tenant is ineligible for the rental assistance. Let's now talk about that safe harbor that I touched on earlier. Again, and this is absolutely worth restating because it's very important. And one of the reasons why it's unlikely that we're seeing a true surge, a true wave of evictions. One of the things we've been talking about, certainly a lot more last year than we have this calendar year, is the possibility of a giant number of evictions happening at once. And when we were talking about that last summer, last fall, even last winter, well, you know what? There wasn't $600 or $700 million from the federal government in the state safety deposit box, wherever they keep the money around here. And so that is why the safe harbor is in place to access that money. But it's also that money is why we haven't seen the surges. And we'll talk about how many evictions we're seeing right now in a second. But the surges didn't happen. And there's no real illusion about why they didn't happen or why they haven't happened yet. It's because there's this giant pot of money that's helping make tenants whole, make landlords whole. With the theory being behind all of this is that a lot of people lost their income source, not through any real fault of their own. They were ready and willing to go to work, but their work disappeared and it threw everything into chaos. And it's been difficult for the rest of, for everybody to get caught back up onto where they're supposed to be. So June 1, 2022, pending application is still a defense for a tenant in a non-payment of rent case. If they have a pending application. This is an important sort of buzz phrase. One of the key takeaways I always want somebody to take from where we are right now is this is in place through June of next year. All right, let's look at whether the eviction rate changed when we went into phase 4. Once again, phase 4 started September 12th. And so Let's look at the week prior to that. So that would be, it was a 4-day week. We had Labor Day that week, so only 4 days, but 64 evictions were filed that week. Okay. The week following the phase 4, so we went into this new phase where landlords suddenly had the right to file an eviction for a new reason. They'd reaccumulated this right. There were 125 evictions filed statewide. And then we go to the next week, the most recent week that we have data for, we're into the following week. So is 130 evictions filed statewide. So going up slightly. Keep in mind, how many evictions are in a normal year statewide? It's not that easy to actually answer that question because evictions aren't just landlords evicting tenants from residential places. It's also commercial evictions. So if you don't pay your rent at a strip mall, if you're a small store owner, it's the last phase of a foreclosure as well. So you can't just say how many evictions there were there and know the answer to how many landlords evicted people living in rentals. You have to dig a little bit deeper, but our best guess is 15, 20,000, somewhere in there each year annually. So we're using 16,000, which would average about 307 per week filed statewide. Still well below, less than half kind of an average week in an average year. So the surge that people were very concerned about 12 months ago still hasn't hit, if it ever will, because of the fact that we've got so much federal money coming through that will hopefully get tenants paid up. Let's look at a chart sort of explaining this as well. Yeah, so we can see that evictions we actually have the data from the week prior to the previous slide as well here, showing the end of August and into early September. We were up to about 110 there, and then it dips down, and then it shoots up, and now it's continuing to climb. Where will it be next week? It's hard to know. Maybe it'll continue to climb as landlords realize that they have this right more and more, this reaccumulated right to file an eviction if a tenant is behind on rent and ineligible for the rental assistance. We'll have to see. But this is it's a month's worth of data almost, and so it's useful to see sort of what's happening as the phases change. Okay, another question we should answer here is, what is a pending application? I've mentioned this, I don't know, 4 or 5 times already in the last 15 minutes. And a pending application, there's some definitions that we have. It's been submitted and has not been denied, withdrawn, or paid. An incomplete status is not the same as pending. If payment is deemed ineligible, there will be an update in the system, written denial notice with reasons sent to the tenant. The tenant might be able to reapply or appeal, however. And if there is an appeal filed during the appeals process, the application is considered pending. So those are sort of the black letter versions of what we have defining what pending means. And I think it's something that we're going to be seeing defined through case analysis as well as we go further into the off-ramp phases. Certainly past October 12th, it's going to be a much bigger role. Why would a tenant not be eligible? Probably the most common reason that we've heard is, go ahead and shift the slide, Eric, is income eligibility. So this is defined, I think these are federal declarations that get passed down and sort of determined in each county. So it's a county-wide analysis. It's not a city-wide analysis. It's not a court district analysis, which isn't the same as counties necessarily. It's a county-wide analysis. And so you can sort of guess where the highest area median income counties would be. They tend to be metro-centric counties. But we have the list of the ones that are the most, the highest area median income. The lowest area median income counties are quite a bit less populated, and we can see the numbers here. Up to 80,000 roughly in the more populated counties, up to 60,000 in the less populated counties. But there are 8 or 9, maybe even a dozen different levels depending on which county you're looking at. So if you're a tenant or a practitioner or a landlord in a county and you want to know whether or not somebody's likely to be eligible and you happen to know the income of the family, this is how you try to track it down and determine whether or not an eviction is fileable. All right, on to the last point I want to make, which is the CARES Act. So the CARES Act is federal legislation. I've been talking about solely state peacetime emergencies, state off-ramps. Those were state law specific things that I was discussing. But the CARES Act is a federal law. So everybody's heard of the CARES Act, right? That was the first major piece of legislation that we had during the pandemic. If it was April or March of last year, I can't remember which, but this was at the federal level. And at that time, we had a Republican majority in the Senate, a Democrat majority in the House, and President Trump, a Republican as well. Very bipartisan law that was passed. I don't think it was unanimous, but it was very bipartisan. And it had a lot of components to it. That's where we first started to see the stimulus payments, both at the individual level, along with the small business bailouts starting to happen. And so that was the first wave that we had of that, but it wasn't all that was in the CARES Act. There was quite a bit of topics covered, and rentals were covered as well in the CARES Act. So here's why we're talking about this, because there's a deadline that was in the CARES Act when it comes to housing. The first thing that I should mention is that there was an actual non-payment eviction ban in place. And this was a federal ban. This wasn't just in Minnesota. This was a ban throughout the country. But it ended specifically on July 25th, 2020. Once again, not a typo, 2020. So that was last year that the CARES Act eviction ban ended. So why are we talking about this still today? Well, because of the fact that the CARES Act has a 30-day notice requirement built into it as well. So the right to file an eviction, that ban ended July 25th of 2020, but this 30-day notice requirement didn't end. It didn't sunset, as lawyers say, or legislators might say. And so it's still the law. It's still the law that we have going forward until probably Congress changes it, or some court decides that it's not legal, I guess. Those would be the two ways that I could think of where it wouldn't be in play anymore. So what does this 30-day notice requirement do? Well, we'll go back in time a second. Let's say it's July 26, 2020, and you're in a state that doesn't have any eviction moratoriums of its own at all. There were states that never had them. And so on July 26th, as a landlord, if you wanted to file an eviction, you might be able to, depending on whether or not you were a CARES Act covered building. So what's a CARES Act covered building? Well, if there's a federal subsidy of any type, chances are it's a CARES Act covered building. There's actually a definition in the law, and it refers to, hey, anything covered by VAWA, the Violence Against Women Act. And there's a lengthy definition of places that would be covered in VAWA. Then the CARES Act covers that. It also can cover smaller buildings where there's a federally backed mortgage even, like Fannie Mae or Freddie Mac. And so we've never been exactly sure how many buildings are covered by the CARES Act because it hasn't been to the fore yet. But our best guess has always been somewhere between 20 and 50% of Minnesota rentals are covered by the CARES Act. We're not sure. So if a landlord has a non-payment of rent case that they wanted to file, they should check and see if they are in a CARES Act covered building. They should be able to figure out what kind of mortgage they have. And they might be the only party that can really do that effectively. So that's why the CARES Act still plays a role versus, I don't even have a slide on the CDC moratorium anymore. It's been overruled or overturned by the US Supreme Court. So it has no role in Minnesota, nor did it ever really have a significant role in Minnesota. But the CARES Act might be the one that has a lasting role in Minnesota. And kind of forecasting legislatively where we are nationally, I believe that the federal House and the Senate, I don't think that either can be flipped this calendar year. So I think this will be in place probably until at least January of 2023 would be my best guess, that the CARES Act will still be there unless, like I said, there's some court challenge to it that's successful. I just don't see the political makeup at the federal level where they would abolish this 30-day notice requirement, nor do I think there's been much political asking for it either. I haven't heard of that, and this is the kind of thing that we sort of keep tabs on as frequently as we can. So anyhow, that is our snapshot of where we are today, what we've been doing for virtually every one of these 65 sessions that we've done. But now we're going to turn it over to Eric, and he'll introduce the referee.
Thanks, Mike. And I'm going to stop my screen share here so that the referee can take over. And while I'm doing that, provide a little bit of an introduction. So first of all, thanks for joining us, Referee Houghtaling. Give me 1 second here. So yes, referee Houghtaling was appointed to the 4th Judicial District Court in January 2018 and is assigned to the civil and criminal divisions handling housing, harassment, expungement, and petty misdemeanor matters. Prior to this, referee Houghtaling was a human services judge for the Minnesota Department of Human Services, an appellate attorney for the Minnesota State Tax Court, a private practice litigator, a conciliation court referee for the 4th and 2nd Judicial Districts, and a hearing officer for St. Paul Public Housing Agency. Referee Houghtaling is also taught as a professor at several institutions of higher education and participated as a volunteer with the Volunteer Lawyers Network, is past co-chair of the St. Paul Human Rights and Equal Economic Opportunity Commission and the Minnesota Lavender Bar Association. And so the referee is going to join us to share a little bit about what is going on in Hennepin County's housing court. So welcome and thank you, referee.
Thank you, Eric. I don't know that I've had an introduction like that in a long time, so thank you for going over all of my past accomplishments. I appreciate that. I thought today what I'd talk a little bit about is sort of the 4th Judicial District's perspective on what's going on and how we're proceeding with cases. So for those of you who appear in Hennepin County Housing Court, hopefully this isn't too boring for you. I hope that you have questions because I really want to address whatever burning questions people have. But to get started, I thought I'd talk about the first appearance calendar structure, some updates from the 4th Judicial District, a little bit about Hennepin County specific statistics, what has changed, what's remained the same, and the future of virtual court with some practice pointers and reminders. What's a little bit different about the 4th that some jurisdictions or venues are doing differently in Minnesota is that, at least in the 4th, we're not reviewing any of the filings that come in for evictions. So any filing that comes in for a first appearance or is scheduled for a first appearance within the 14 days required, unless it's rejected for some other type of filing deficiency. I know that in other counties and judicial districts, they are doing a review of eviction filings for whether they meet some sort of statements related to the phase out or the CARES Act. But we've determined that that's not appropriate for us in the 4th. We are holding first appearance calendars on Tuesday, Wednesday, and Thursday mornings at 9 o'clock. And we're likely adding a 4th first appearance calendar in the coming weeks as we are seeing our filings increase and the need for another first appearance calendar coming in the coming weeks. We're currently scheduling 15 cases per calendar. Sometimes we'll do 20 if we need to. We're really trying to make it so that we can get all of the cases handled within that 3-hour period that we have allotted for the first appearances. And 15 seems to be the appropriate number. I will say that this morning I was surprised, out of my 15 cases that were scheduled, 9 of them were defaults, but we still went all the way until noon with only 6 cases being contested. So it does take some time to work through the cases when we require people to talk to one another and for people to access the services that we have available. One of the things that's changing in the 4th is that starting October 1st, we are switching our Zoom format a little bit so that for each courtroom, there will be a single meeting ID and password that will just reoccur every single day. So if we're in courtroom 356, that it will have the same meeting ID and password every single day so that you won't have to keep track of multiple meeting IDs and passwords. That also helps us when we're writing orders because we were having some mistakes happen if we picked the wrong meeting ID and password. Currently, the process that we're following for non-payment cases with the pending COVID-19 emergency rental assistance application is that we're staying the case, we're making it confidential, and then we're allowing either party to file a request that the case be reopened and scheduled for another first appearance once the status of the application comes back. In terms of updates from the 4th, we have a new referee Frank Reed. He will be hearing more and more housing cases as we go along. He's sort of been getting his feet in some of the other areas that he covers, but you will be seeing him more in housing court in the coming weeks. We also have a new attorney service provider. We have Hennepin County Adult Representation Services, or oftentimes referred to as ARS, And they are offering representation to all tenants who meet income qualifications, which for ARS is going to be 150% or less of the federal poverty guideline. So you'll see quite a bit more representation of tenants in housing court because ARS is now taking all tenants full representation who meet that particular income qualification. VLN and MMLA are continuing to offer representation to tenants who meet those organizational requirements. And I know that MMLA has a contract with the city of Minneapolis, and so they are handling the city of Minneapolis cases for tenants. You may have noticed that we are no longer conducting mediations at first appearance calendars. However, we are ordering mediation sometimes before a trial will take place. Typically, I'll order mediation if I have two self-represented parties who just haven't been successful in negotiations. I like to think that attorneys are able to facilitate the negotiations pretty skillfully without having a mediator involved. If you want a mediator and there are two attorneys, we are more than happy to refer you to mediation services because the court continues to have a contract with them and it is free for anybody who wants to participate. So even if the landlord and tenant want to go without attorneys, that's fine as well. Just let the court know and we'll go ahead and get that ordered. And then finally, we are initiating a Sharepoint hub for housing court information. What that means is that we will have a Sharepoint site that is available to any court partner. So landlords, landlord attorneys, tenant attorneys, and anybody providing resources to tenants or to landlords. And you can sign up to have access. You just have to request a DMZ account request. You'll have access to the Sharepoint site. And what we will do is that's where we will provide all of the Zoom information for the courtrooms, the calendar structures in advance. We'll post documents there pertaining to housing court, such as standing orders or other notices that might be useful to people who appear in the fourth. So I think this will be a great way for us to communicate with some of our court partners and for you to get information about the court, because I think sometimes people don't know where to go or who to ask. And if you get this DMZ authorization, you will be able to get in. To request that, you can always email chambers and our law clerks will guide you to who to contact for that. And we'll make sure you get connected. All right, so I know that Mike went over the statistics a little bit for statewide, but I thought I'd tell you a little bit about what's happening in the fourth. So in June, we have 45 evictions filed. Then after the moratorium or phase out was enacted in July, we saw 119, in August 170, and then as of today, we have 187 evictions that have been filed. About 25% of those cases have been scheduled for trial. So I would say our trial numbers are going up and our trial calendars are becoming busier, as are the number of eviction filings. I also wanted to show you, I don't know who had an opportunity to view this before, but I was going to show you a website that was created by Hennepin County to provide statistics on evictions in Hennepin County. So I've got it put up here. Sharing screen. So this is available to the public. And if you Google Hennepin County eviction statistics, this should pop up for you. But essentially what this has done is it creates a real-time tracking of eviction filings by case type, how judgments are being entered. You can filter it by year, so you can sort of see year by year how things have changed or stayed the same. And of course, this is going to be slow because we're on Zoom. Those are the sorts of things that you can see on the first page. When you go scroll through using these bottom arrows, some of the things that are interesting about this is that Hennepin County has gathered information about eviction filing rates by zip code, information about income, poverty rates. You can also see where the largest number of eviction filings are located by zip code. You can do a number of different types of filtering, but this is the information that's provided to the public. So it's an interesting website that you can access if you're looking for data on evictions in Hennepin County. What I will tell you is that this data does change, not only based on how filings occur, but as expungements take place. So as the court expunges records, it will change this data because the Hennepin County dashboard is just pulling from court records. And so as cases are expunged, they are essentially eliminated. And so that'll make these numbers skewed a little bit. But just knowing that it excludes expungements, it's some interesting data if you're interested in that sort of thing. All right. So then the other thing I wanted to draw people's attention to is that we do have some new ordinances that have gone into effect over the last couple of years. And it's a slightly different process now. So not only do we have the 15-day notice that's currently required by the phase-out legislation, but Minneapolis and St. Louis Park have also initiated ordinances that require some notice before filing for non-payment or other unpaid financial obligations. So the city of Minneapolis requires a 14-day notice before bringing an eviction action for non-payment. And then the St. Louis Park ordinance requires seven-day notice before filing. Both notices require certain things be included in the notice. So the total amount due, there needs to be a specific accounting for how that total amount was calculated, the name and address of the person authorized to receive rent and fees. And I think what's interesting about that is sometimes landlords will be accepting rent payments electronically, but I do think that this notice does require that there be a physical location that rent can be delivered to, so that if the automatic payment feature has been disabled for some reason, that the tenant would not be rejected from paying because they weren't able to access it. Providing a description of how to access legal and financial assistance through the city's website. And then the notice must be delivered personally or by first-class mail, except the St. Louis Park ordinance does allow the parties to agree in writing that an email notice would be sufficient. I know that some of the questions that arise is, we have all these different notice deadlines. So for the phase out, it's 15. For the Minneapolis, it's 14. For St. Louis Park, it's going to be 7. Do I have to send separate notices for each one? And from my perspective, you would not, so long as the notice that you're sending complies with the longest period of time and includes all of the things required for any type of pre-filing notice. So the phase-out legislation requires slightly different things than these local ordinances. But if you complied with the 15-day notice, that would sort of encompass a 14 and a 7-day as well, so long as you provide all of the required information. So Mike went over, what sort of has been changing and what has gradually been increasing in terms of the types of eviction actions that can be filed. But I think it's important for us to review what remains the same and what still applies, because what I'm seeing frequently is people sort of forgetting how we used to do this, people forgetting sort of what the basics of the housing court practice is going to be. And so I just encourage everyone, if you're sort of rusty on your housing court or eviction case filing laws and procedures, review that information before you come. So make sure that you're reviewing the housing court rules for Hennepin and Ramsey County, which are the general rules of practice 601 to 612. Take a look at 504B again, the rules of civil procedure and the rules of evidence, those always apply. Make sure that you remember that for service purposes, you have to follow strict compliance per Koski versus Johnson. We still have the relatively fast timelines here in Minnesota for eviction filing. So from the day you file, you're going to be in court within 7 to 14 days. I don't think have ever past that 14-day deadline as required by statute. So we will get people in if that means adding a calendar or overbooking a calendar. We will follow the statute and get people in within that 14 days. And then the general causes of action for landlords and tenants haven't changed, with the exception of some restrictions in terms of when those types of cases can be filed. People also ask me about what is the future of virtual court. So as you know, we hold our housing court matters via Zoom these days. And for the foreseeable future, housing court matters will continue to be held remotely. We found that it's advantageous for those who have transportation or time constraints, but we do also realize that it does create some barriers related to accessing technology. And we've been trying to connect people as best as possible to technology. If they arrive to the courthouse, we try to connect people with a way to get into the Zoom hearing if they're at the courthouse. I think it's also useful for attorneys who are appearing in multiple jurisdictions. Maybe on one morning, you can jump into a hearing in Scott County, at 9:30 and be in another hearing in Hennepin at 10, which previously would have been impossible. But as far as I know, and as far as what we've heard from the post-pandemic working group that's conducted by the State Court Administration, it looks like housing court is going to continue to be conducted virtually. Some of the things that I would encourage people to do is to practice using Zoom. I know that even after using it for a year and a half, I think the other day I forgot to unmute myself. So it is something that is frequently forgotten, but particularly if you don't use Zoom very often or you've never used it before, I think it can't be said enough to practice with your clients, practice with your staff. The things that you could practice are muting and unmuting, create some breakout rooms, have people go into the breakout room, practice leaving the breakout room, know where the little buttons are. If you're going to have clients or you are going to need to connect using an app on your phone, make sure that you know how that's different than using it on the computer. Also try to access Zoom in a variety of ways so that you have experience with the different types of technology so that you can guide your client or even So yesterday our court VPN was down, which means I could not access my hearing on my work computer at all. So I couldn't use Zoom, anything like that. So I had to use my home computer, which is a Mac. Work computer is a PC. And then it was suddenly me having to remember how Zoom is different on a Mac versus a PC. And so it's useful for you to know that if your clients are going to maybe have a technology issue, if you have a technology issue, or if you have to jump on the phone, all of a sudden something happens, you get disconnected from your Wi-Fi at home, so you need to use your cellular device, whatever it might be. I just think that all of the practice you can get on Zoom will both reduce the anxiety that exists for either you or your clients, and also just make the whole experience hopefully less stressful. When you're joining the courtroom, make sure that you change your screen name. I know I always prompt people to do that, but if you can do that proactively, that's great. Make sure that it clearly represents you and what you're doing there. So, state that you're an attorney and put in parentheses who you're representing. Or if you're the landlord, you can put landlord, and you can even put your case number or the tenant's name. That just helps the clerks in guiding people and knowing who's there, helps us during roll call to make things go more quickly. Make sure that you're identifying yourself if you begin speaking and you haven't been directly addressed. I know that this can be kind of awkward to say your name. It's sort of like talking over a CB radio, if anybody's ever done that. But you got to make sure when the court reporters cannot see us, that they're able to know who's speaking at any given time. And to do that, we have to say who we are. And then finally, pre-label your exhibits. Everyone has been doing a great job at this now that I think you're used to it by sending things in via email to our chamber's address. But the pre-labeling is great. And then if you can make sure that you're reviewing the order for how to label, and you're trying to remember whether you are representing the plaintiff or the defendant in the case, so that you're using the correct numbers or letters, so that we don't have both the plaintiff and the defendant using numbers, or both the plaintiff and the defendant using letters, as that can just be difficult for record keeping purposes and for any court of appeals cases that might go up. So in terms of some practice pointers, and some of the things that have come up recently over the last year is please don't contact us directly if you're contacting us about a case. That can result in some ex parte communication, makes us as referees really nervous when we see attorneys contacting us directly. So just use the chamber's email addresses. We as referees don't have direct access to the chamber's email. That is where the clerks are sort of our clearinghouse to make sure that there's no ex parte communication going on. But we will get, our clerks will communicate with us information that we need to know, but also avoiding any ex parte communication. When I first started practicing law, one of the things that one of the partners at the firm imparted to me was the people that you need to be the nicest to, if you're going to be nice to anyone, is secretaries and administrative clerks. They hold so much power in terms of the ability to help you, the ability to guide you if you have questions, and oftentimes information will get trickled back to us in terms of how they were treated. They have a very difficult job. They're managing the public. They're managing a very stressful situation for both landlords and for tenants, and they're doing the best that they can. We have a lot of new administrative clerks, and so there's a learning curve that's going on. They didn't tell me to say this to you, but this is coming from me because they're so useful to the court and they can be so useful to you, and we want to keep them around. And so please be nice to the administrative clerks, and they will bend over backwards for you to help you out. I've seen more and more that landlords are forgetting to attach the power of authority to the eviction complaint at the time of filing. And again, this might just be, oh, we haven't done these in a long time. We've kind of forgotten what we need to do. So make sure that if you have an LLC, a corporation, or other organization that would qualify as needing an attorney under civil rules, that you are attaching that power of authority to the complaint, and that you're not suing in the agent's own name, but rather you're doing it appropriately and having that power of authority attached. Because it's always frustrating for people when we have to dismiss a complaint on a technicality. I know that people get frustrated about that. So if you just do it right from the beginning, we won't have to do that. Make sure that you're complying with the notice requirements and the phaseout legislation and the local municipality ordinances. For tenant-initiated actions, make certain that the notice has been given to the landlord if required by the statute. So if you have to give a 14-day repair notice, give that 14-day notice and then wait to file until after that 14 days passes, and then attach whatever notices or information you might have to the complaint or affidavit so that we know that that was actually done. One of the things that's difficult over Zoom is that some of the rules, were really written as if we were all going to be in person. So for example, on a breach claim, you have to attach the complaint at the time of filing, or you need to provide it at the first appearance. Well, we're all virtual now. So how do you provide that complaint? I mean, I can have people hold it up on the screen. I can have you hold up the notice that you sent the landlord up on the screen, but that doesn't translate to the other party having that information, which is really what the purpose of those particular rules or the statute are. And so if you can check off those sort of procedural requirements, we won't have to worry about it at the first appearance. And then finally, whether you are initiating a tenant action or you're initiating an eviction action, don't forget about service. Don't forget about filing the appropriate affidavits that might be required for service within a timely fashion, and check the court file before you come to your court appearance to verify that service has taken place. Whether you're the landlord or the tenant, I think that's just a good practice. If something hasn't been served, the court's hands are tied in terms of having jurisdiction over the matter. And so if you want to move forward on your case, the best way to do that is if you verified service has taken place. So with that, we'll take any questions there might be. Of course, just to be clear, I can't answer give any legal advice. I think that's why Rachel Sterling is here. but I can answer any questions about, procedure or Hennepin County specific questions. Thank you.
Yeah, thank you, Referee Houghtaling. Appreciate the overview. And yes, we have a good number of questions submitted in advance and in the Q&A, 15 to 20 or so. Again, we are going to prioritize the questions that we got in advance and over the live Q&A that are most clearly directed to the referee. We'll handle those first, and then Rachel and Michael will tackle some of the other ones. So I'll hand it over to Rachel to start feeding you questions.
Thank you, Sarah, and thank you, Referee Houghtaling. So we've got a few that have come in. So a couple of the pre-submitted ones. So I'll start by saying who's asking the question. I'll read the question, and then you can speak as you see fit. So Dan is he's a service provider, and they're asking, will Hennepin County Housing Courts be accepting motions / arguments for expungement as part of eviction proceedings?
So yes, we typically do allow for a party to request expungement, whether that be at the first appearance or if it's, as part of a trial, if that's the remedy that you're seeking or the outcome that you'd like, if it's going to be a dismissal plus an expungement, you can always make those arguments. And then the court, we'll apply the law as to whether the statutory basis applies or our inherent authority, whether we have further things that we need to do based on our constitutional obligations. But yes, you can always make a motion or a request.
Okay, thank you. Deanna is a service provider, is asking if the court rules in favor of the eviction, can the tenant still apply for rent help amend and then appeal the court decision?
Yes. My answer is yes. So if the court, if there was not a pending application and it was a non-payment of rent case, and the court found in favor of the landlord, and then the tenant applied for rental assistance, I think that there's an argument to be made that until the premises has been restored to the landlord, that perhaps a pending application would cease the proceeding for the writ of recovery. I think there can be an argument made. I don't know how that would come out, but I think that could be an argument. And then as it relates to an appeal of a housing court matter, when you appeal the housing court decision, you have to request a stay and so it would just all depend on what comes out of the order related to the underlying eviction action as to whether it would cease the recovery of the premises or whether there would be a restitution during the pendency of the appeal.
Okay, so timing is important on that one. Perfect. Okay, you kind of touched on this a little bit, but I just thought that for some clarification, Lauren is asking, they're a landlord. And so towards the end of our call last week, we were talking about notices, and they were wondering if you can roll the notices together, kind of like what you were talking about with the 30-day notice and the 14-day notice and the 15-day notice requirements.
I think you can, like I said, I think that it can be all encompassing so long as you have all of the information required by all of the notices in that singular notice, and that you are giving the longest period of time for the notices. So for example, if it's a Minneapolis property, you still have to be in that 15 days or longer. If it's a St. Louis Park property, it'd be 15 days or longer because of the phase out. Once the phase out is gone, then you're going to be back to the 7 and the 14. And then of course the CARES Act notices as well, if you believe those apply. So
yep. Okay. And then this is the last of the pre-submitted questions specifically for you, and then we'll move on to the ones that came in during the presentation. Again, we will come back to the other ones that were pre-submitted that just aren't, so don't flood the Q&A yet with questions that we didn't get to. We'll get to them in a minute. So then Kimberly is a landlord, and they're wondering, what is the rule regarding postmarks for security deposit returns? What are the penalties? Anything else you want to notate about security deposits?
I'm going to be frank. It has been a very long time since I've dealt with security deposits because that's a conciliation court situation. And the last time I was in conciliation court was like 4 years ago. And, you know, when you don't use it, you lose it. So I don't have all that. I know it's like 28 days and you've got to.
Oh, I'm going to cut you off now because you're
Thanks.
guessing. Yeah, 21
yeah,
days.
I'm like, I don't do this. So it's in 504B somewhere.
Sorry, I didn't mean to put you on the spot.
That's okay.
Tell you what, I'll answer this one since it's been asked, and then we'll get back to the referee's question. So the postmark rule is it's a 21-day rule. The 21-day clock starts when two things happen. The tenancy is ended. The tenant is also given delivery instructions where to send the deposit to. And if the landlord doesn't do that, then the tenant can sue for twice the deposit, plus twice the interest they've accumulated, plus another $500 in damages. And if you really want to look up the statute, it's 504B, where almost all landlord tenant laws are in Minnesota, 0.178. That's the security deposit statute.
Thanks for saving me, Mike, because I was wrong like right away. I said 28, it's 21. But like I said, if you don't use it, you lose it. So
As you say, it is a conciliation court and not a housing court thing. So, okay, so moving on then to the ones that were submitted during the presentation. So first off, Joey Dobson from Legal Aid says that it's her understanding that the dashboard that you were referencing does not include expunged cases.
correct.
So just want to put that out there. Next one is from an anonymous attendee. And they're wondering, is it possible to email settlement agreements to the court administration during Zoom breakout sessions at the initial hearing instead of attempting to orally dictate terms to the referee, which can tend to be more haphazard?
Great question. And I love it when someone else writes the settlement agreement and I'm not acting as the scrivener on the record. So you can't email it to the court administration, which is, you know, frustrating. The only way to get it into the court record is if you file it. And I know that then it gets stuck in the, you know, e-file and serve queue and you have to wait until someone accepts it. If you want to email something to the court, you could email the chamber's email addresses for whatever referee is presiding over that first appearance. So the referee's chamber's emails are generally the same format. So they're all fourth referee and then one of our last names, whoever, so fourth referee Houghtaling Chambers at courts.state.mn.us. If you emailed it there and you let us know if you said, we've got a settlement agreement, we've emailed it to Chambers, we can then quickly message our clerk. I'll check our Chambers email and then they'll make sure that we get a copy of it. So it's a little bit back ending things, but for sure we would accept a settlement agreement in that form. It just takes a little bit of communication between us and our clerks and for you to let us know that it came in so that we can get it right away. But we do that for our harassment hearings, actually. The mediators always email Chambers the settlement agreements and then we get them just right then on the record. So we would accept that.
Okay. And is that fourth spelled out or is it the number TH?
It's 4TH referee and then whose ever last name,
okay.
Chambers, yep, at courts.state.mn.us.
Okay, perfect.
And it's in our orders. So if you have one of our orders, you'll see that it has that Chambers email address in it.
Perfect. Thank you. All right. Things got a little out of order here. So another anonymous attendee is wondering, what are some of the most common violations of housing court rules 601 through 612 that you see?
Common are going to be the power of authority issue, where the landlords are not attaching the power of authority at the time of the complaint. Service issues or filing of affidavits of service. That's going to be the next one. And then for the most part, people follow the rules pretty closely. The way that I interpret the housing court rules is that they apply to eviction actions. So my reading of the rules is that the housing court rules apply to eviction actions because they all say unlawful detainer. It's like all over those rules. It doesn't say anything about rent escrows. It doesn't say anything about emergency tenant remedies actions. So one of the things that I require in a rent escrow or an ETRA or lockout is that if the landlord is an LLC or a corporation, that if we're going to have a trial in the case, that you have to have a lawyer, that a power of authority wouldn't cut it. That's my reading of those rules, so that it's not really a violation of the housing court rules, but it's sort of how I think that they do or do not apply.
Okay. Thank you for that. Okay, Timothy Balland wants to know, do you anticipate any delays caused by the volume of evictions?
We do not. So we have been anticipating an increase in the number of evictions. We have essentially discussed and established a calendaring system where we could handle up to 400 initial appearances a week. I don't want to do that. Okay. Everybody who's listening right now, like nobody wants to do that. I don't think you want anybody at the courts to be doing that. It's really not any healthy way to exist, but that is what we will do if we need to. And if it's more than 400 a week, we can call in some backup to help us. But then you're going to get judges who never do housing court, and you never know what you're going to get then.
That sounds really unpleasant all around. And then Tim is also wondering if the court is accepting electronic signatures, specifically in settlement agreements, but other applications probably.
Yep, we accept electronic signatures for anything.
Okay. Perfect. Okay.
I had a couple questions I was hoping to ask, if I could. We have a broad audience, and some of the people out there might be pro se landlords or pro se tenants that might appear in front of you at some point. Pro se is unrepresented, so there's no attorney representing somebody. In your court, you see pro se litigants. It's one of the things that you run into fairly regularly versus other judicial officials. What's your advice to pro se, both on the landlord side and the tenant side?
Well, that's a really good question. So for self-represented litigants, one of the things that's important to remember is that the court has an obligation to stay impartial and neutral. And so we try to help people as much as we can in terms of understanding what's going on. But there's a difference between understanding what's going on and giving you legal advice. So there's a fine line that we can walk in terms of helping you understand what's going on and telling you what you should or shouldn't be doing. For self-represented litigants, you are obligated to sort of know the rules, to understand the rules, to follow the rules, to follow the law, and you're actually held to the same standard as an attorney would be held to. And whether that's fair or unfair, that's the way that the law is written and how we're supposed to proceed. Regardless of that, as I said, we do try to help people as much as possible understand why we're doing what we're doing. But we don't make the rules. I think that's, and I think I said it 3 times during my first appearance calendar this morning, that I don't make the rules. I just have to apply them. And I have to apply them the same to every party, whether you're represented or unrepresented. And so we as judicial officers understand that it's frustrating and it's complicated, and it's a system that maybe is supposed to be set up so you don't need a lawyer, but you kind of really do need a lawyer. And so if you can remain cool under pressure and not blow up at us, that's usually advisable as well, to sort of take your knocks and then regroup and try it again if we're giving you information or news that you don't really like.
So just to be clear, don't yell at the judge is your
is
a good piece of advice. Yeah, I can see that. Sure.
I mean, you can, but
right.
You'll probably end up before us again, and we're going to remember that you weren't very nice to us the first, like we're still people. Right. So yeah.
So the other question is maybe it's a more philosophical question. You mentioned you had a small group of cases this morning, but it still took up a good amount of time. And I don't remember how many it was, 5 or 6 that sounded like they took a couple hours.
Yep.
Is what it sounds like. And then you also talked about taking 400 cases a week, potentially. I don't know that it's possible for, let's say there is a flood of cases, 400 cases in a week. I don't see how you could give all the cases the air that you were able to give the cases this morning. there has to be some sort of efficiency trade-off, right? If that kind of volume happens, or even if we get back to normal levels.
Well, so the way we got to 400 is it's not necessarily that it might be slightly more cases in the same period of time. We're just going to give more time to first appearances, if that makes sense. So like right now, what we're doing is we have one calendar going, 2 to 3 times a week with that 15, 20 line calendars. What we would begin doing is we would have first appearance at calendars every single day, all day long, with 2 referees going all day. So it would either be referee Cedios and Reed or Cedios and me, and we'd just be in first appearances all day long, every day, hearing 15 to 20 cases and potentially putting 3 of us on initials all day long, every day.
So about 60 cases a day between the 3, is that what I just heard there? Okay.
Yeah.
So then to get to 400, you'd need somebody to still take on another 100 cases. So that'd be judges, right?
It could be judges, or we would potentially put on, well, no, because it's 120. So if all 3 referees are going and we have 3 calendars every morning, 3 calendars every afternoon.
Right.
That's 120 a day.
Wow. Maybe we shouldn't try to do math. Maybe I had it wrong. Yeah.
So if we had 3 calendars going in the morning with 20 line calendars.
Okay.
And then 3 calendars in the afternoon with 20 line calendars.
Oh, I'm sorry. I thought you were saying 20 per day per referee. You're saying 20 per shift, basically. 20
per shift. Yeah,
Got
20 per morning, per afternoon. And the reason we said 400 and capped it at that is for our own mental health. So that we could have an afternoon or a morning or a day where we weren't doing this.
Okay.
So
Great.
that's how we got to like 400. We're hopeful that we never have to get there, but yeah.
And that was a question that was just submitted. I think it's what I asked, but I'll just ask it anyway. They're asking specifically how many referees, judges would be necessary to handle 400 cases a week?
So 3 referees.
Yeah. But you're talking just initial appearances, of course. Any actual trials, that throws a huge monkey wrench into things.
Correct. We have sort of we have like a chart configured in terms of, we calculated, and it's something like in a normal time, like 8% of our cases go to trial.
Okay.
In normal days, right? Before pre-pandemic, we had 8% of our cases going to trial. So we sort of calculated it that way to sort of figure out how we could fit in trial blocks along with the first appearances. So we'd fit everything in sort of on a rotational basis. Trials are less stressful on us than first appearance calendars. So, having an afternoon or morning off from a first appearance, but putting a trial into that slot is it's not easier for us, but it just sort of gives us a little bit of a breather.
Yeah,
That
I've
makes
never
sense.
heard
For judicial officers. So
I've never heard a referee say that. I've known several that have sat in your chair before, and I've never heard them say that trials were less stressful than initial appearances. Can you say why that is a little more?
So I don't know that it's a different type of stress. So first appearances is a lot of management of a lot of people, a lot of different expectations, and a lot of things being thrown at you for the first time without ever having reviewed anything in advance, right? So when I jump into my first appearance calendar, sometimes I have, 10, 15 minutes the day before to quickly look through the court file. But most of the time I'm just jumping in there. I don't know anything about any of the cases. I haven't been able to review anything. And so everything's being thrown at me just as I'm sitting there, right? Which is fine. And that's the way we've always done it. Switch over to a trial. And for a trial, I have reviewed the case. I have an understanding of, sort of what the issues are going to be before me. If I have 2 attorneys, they've probably talked in advance. We've got exhibits that are marked. It's just a different pace of things, and it's a different type of interaction that takes place at a trial. So trials can be also stressful, depending on how people are behaving or interacting. But for the most part, it tends to be a bit more structured and predictable. So I think that for me, at least, trials are less stressful than first appearances.
That's interesting. Thanks for sharing that. I don't have any follow-up questions. Are there any other questions, Rachel, that you see that have come in that look like they're targeted towards the referee?
One of them was just a comment of how on earth could the court do trials with constant initial appearance calendars? So I think you covered that nicely.
Yeah.
Thank you. I think, but that was the only other kind of comment. Sherry just says that this has been super interesting, so thank you. And I would like to reiterate that.
So I will say, I mean, we do have judges on backup, right? So essentially we see our job is to make sure that we are complying with the statute, complying with the rules, making sure that we are fulfilling our duties under the Constitution. So if that is that we are required to have a first appearance within 7 to 14 days, the district has had conversations about how we make that happen, and how we bring people in to help make that happen. Because it's not just, the referees or the judges, we also have to look at our staff, right? And so one of the questions we always have is, okay, so we have 3 initial appearance calendars running all of the time, and we have 2 administrative clerks per calendar. Well, that's 6 administrative clerks. Well, that's all we have. So then who's answering the phones? Who's handling things at the counter? Who's taking in the filings as they come in? As if we're getting, 400 filings a day, how are those getting processed? So the system is more than just, what can the referees do? But we are a full team, and we have to look at the entire system to see who is available, what courtrooms are available, court reporters, clerks. And so that's sort of where things stand. And we realize that, we hope I honestly hope that doesn't happen, and it doesn't look like it's going to happen. So I'm grateful for that and all the work that everybody out in the community has been doing, and landlords and tenants working together to get, the rent covered and without having to come to court. So
you mentioned judges there. It's always an interesting question to me is how much judges ask somebody like you for insight into landlord tenant. I mean, you deal volume wise with, I think, more evictions than maybe any other judicial official in the state, I would imagine.
Yeah.
So do you get inquiries from not only judges in Hennepin County, but sometimes from outside of Hennepin County saying, hey, I got this, am I missing something, or what tips do you have for me?
Yep. Yeah, for sure. People, other judges contact me or referee Cedios. I just did a webinar specifically for judicial officers, on one webinar on evictions, one webinar on tenant initiated actions, and it's available for judges to watch whenever they might want to. And then they're always welcome to reach out and ask any questions that they might have, and they usually do. So, and I
It had to
did
be a flattering question the first time a judge called you and asked you to explain a lot of them, right?
Yeah, and then I said, oh, I have a question for you too. So
kind of honestly along those lines, one of the questions that just came in, has the court been seeing an increase in Rule 60.02 motions following default appearances? And for those who may not know, a 60.02 motion is if there's a mistake or excusable neglect, something that may have gone wrong accidentally, and they want, and the person who's doing the motion wants the court to re-look at it, essentially.
Yeah, so I've been surprised that there haven't been more. What I will say is that if I compare volume to volume, right? So volume pre-pandemic Rule 60.02 motions, I probably saw more Rule 60.02 motions pre-pandemic. However, the volume was much larger. And so I would anticipate that now. I think if I were to look at the volume and the Rule 60.02, I think it's probably comparable. And most of the time, the Rule 60.02s have been related to, sometimes a misunderstanding about the pending application status, or the notices, and service and that sort of thing. So those are usually the Rule 60.02s that I see. It's rarely, and surprisingly, it's rarely that people were unable to access the hearing because of technology. We thought that we would see a lot of Rule 6002s because of that. Either they came to the courthouse and didn't realize they had to be online, or they couldn't get into the Zoom hearing. And I honestly, I think over the last year and a half have only seen that one time, which I was really surprised about. I thought that would be more frequent, so.
Okay. Yeah. Interesting. Well, it is 2:45 exactly. I don't have any questions in the queue right now. Mike, did you have anything else? Or did you want to start in on the
I'm happy to start in. I don't have any more questions, Eric. I'm not sure if you do, but we could probably let the referee go 15 minutes early, or she's welcome to stick around and listen to us answer these other questions that aren't referee specific. It's up to her.
Yeah, agreed. Thank you.
Yes, well, thank you for having me. I have another engagement at 3 o'clock, so I will sign off and say goodbye, but thank you for having me, and best of luck as you continue to educate everyone as to how to move forward here. Thanks for all the work you're doing.
Thanks again.
Thank you.
Thank you. Bye. Okay, let's bounce back quickly to the pre-submitted questions that we had. Mike, are you ready?
I am ready. Let's go.
All right, let's do this. We've got, all right, 15 minutes to get through, I think another 15 questions.
No problem.
Ryan is a service provider and they are wondering if a building is sold and the lease is month to month, does it always roll over to the new owner?
Not always, but almost every time. The rule that we like to cite when it comes to a change in ownership is that the new owner steps into the shoes of the old owner. It's a weird lawyer phrase, but what it means is you take the contract and you insert the name of the new owner where the old owner used to be, and that's probably what you're going to have. Now, we do see exceptionally, I think it's rare leases. I was going to say uncommon, but it's not a strong enough word. It's a rare lease that changes that rule, but generally, if there's a new owner, they have to abide by the lease that the old owner had in place with the tenant.
All right, fantastic. Scott, a landlord, I think, so rent help MN covers tenant through the end of November. It sounds like they've got a specific tenant in mind. If December 1st arrives and the tenant doesn't pay rent, can I evict given the lease ended?
Well, I mean, we look at kind of our chart of, and Eric, maybe we should repost the chart for the remainder of the questions that we have, if that's possible. But we look at our chart, and the only exception that remains from the off-ramp during the time that Scott is referring to, so this would be in December, is that the tenant has extra protection if they have a pending application through Rent Help MN or some other process. So I think the only way it would matter is if the tenant is reapplying, which might be conceivable if they had a certain payment up to a certain time, but they didn't exhaust the maximum number of months that they had. It's theoretically conceivable that they might still have some protection because they would have a repending application, I think would be how it could work.
Okay. All right, moving on. Michael, who is an attorney, we think, is asking, can landlords give notice of non-renewal of a month-to-month lease without consideration into whether a tenant is behind on rent?
So Michael's not asking specifically about when this would happen, which really matters quite a bit. We're still in our pandemic, so right now a landlord can't just give a standard non-renewal or notice to vacate, which is the traditional rule pre-pandemic. Once we're past October 12th, can a landlord give a non-renewal for no reason at all? That is the old rule. And so it's likely that they'd be able to do so. They'd have to do the right amount of time and it would have to be in writing. But it's possible that a landlord could give that notice. Now, if the tenant's behind in rent and they have an application pending, that does call into question the landlord just giving a generic notice at that point, that maybe the reason for it is for non-payment of rent. And I think that if the landlord has been demanding rent repeatedly up until that notice is given, that might be a sign if the tenant were to argue some sort of retaliation that the tenant's asserting a right to get rent help MN and that notice shouldn't be valid for that reason. I think that would give the tenant a little traction in that argument.
Okay. Similarly, Jackie is a landlord and is wondering if a tenant can be non-renewed on October 12th if they have a pending rent help MN application.
Again, we're trying to get into the head of the landlord to figure out why did they give the non-renewal. But if it's for non-payment of rent, then that's clear. And some landlords will actually put that in a notice. If a landlord gave a generic, hey, get out at the end of November notice on October 12th, even though the tenant owes a bunch of money and they have a pending application. Is that an argument that the tenant could make for retaliation? Well, again, if they've asserted that right within the last 90 days, I think there's an argument that there's a presumption for retaliation. We're talking about things that we have never tried before, though. These are best guesses based on past information that we have, plus the current information. We don't know exactly how courts are going to deal with those things going forward on October 12th.
Okay, and then finally, from the last of the pre-submitted questions, Christine is a landlord and is wondering, she's saying that several tenants are not paying, and when we file non-renewal or evictions, then they apply for aid and let stall is what she's saying. So she's asking, what can we do?
Yeah, and honestly, I'm not sure how much can be done from an aggressive landlord sort of point of view. We have the rule, and the rule says, interestingly, a landlord can't initiate an eviction through June 1st of 2022 or proceed with an eviction. We actually heard the referee talk about how a pending application might still stop an eviction from going forward once the decision has been granted, but before the tenant loses possession, which I think is probably accurate. And so when the legislature came up with this and the governor signed it, they decided not to just have initiating evictions, but initiate or proceed with evictions. So that means it can stop an eviction mid-eviction. So as unsatisfying as that answer might be for a landlord, I think that's the right legal answer.
Okay, thank you for that. We'll swap over to the Q&A questions here, and we'll get through what we can. We have about 8 minutes. So some of these we can probably go through pretty quick. They're kind of reiterations of things that have been discussed before. So again, April asked right away at the very beginning of the presentation, they were wondering if someone has a pending rent help application on October 12th, can the landlord still file non-renewal of lease, or is that part of the June 2022 off-ramp?
Yeah, we've already sort of answered this. I'll only point out one phrasing there that I would care about, which is April mentioned the filing of a non-renewal. Landlords don't really file non-renewals. They give the tenant a non-renewal. They file an eviction for what's called holding over if the tenant doesn't leave by the time that the landlord told them to leave by. So it would be a filing for holding over, not for non-renewal. I know it sounds like quibbling, but trust me, if you're filing an eviction, you want to make sure you're doing the right language as well. But again, I think we'd probably look at a lot of different circumstances to try to figure out if we can glean from what the landlord has been saying and doing, texting, emailing, maybe this non-renewal is about non-payment of rent, but we're not exactly sure how this is going to play out until it gets to courts.
Similarly, so again, another Timothy Ballin, you kind of covered this already in the slide, but how does the landlord prove ineligibility? I think that question was was asked before you put that slide up.
Income eligibility question is probably the one that's going to answer that for most cases. Yeah.
Yep. Anonymous is asking, does a landlord waive the right to demand past due rent if they accept payment of current rent? According to Minnesota Rent Help, tenants should continue paying rent while application is pending.
Does the landlord waive the right to demand past due rent if they accept payment current rent? No, I don't think that. No, there are waivers that happen, and so it's not a silly question by any means. When a landlord accepts rent, knowing about a past breach, for instance, they might be waiving the right to evict going forward. But non-payment is not a breach of the lease. It's a different type of case that a landlord would be filing, and so I don't think the landlord is waiving the right. So I guess the landlord is sort of imagining a shrewd tenant that is behind 10 months of rent, and then they write on their check, and in the memo portion, they say October's rent, right? So it's not being applied to the last known debt, is the theory that the tenant has by writing that on the memo portion. I don't think it waives the landlord's right to chase the tenant for that money, no.
An interesting question from Julie, she's saying that they have residents who fear that accepting rental assistance, I'm assuming that means the Rent Help MN, because there are other sorts of rental assistance out there, but accepting Rent Help MN will count as taking public benefits and show up as negative on their immigration record. Is there an official ruling on this? So we've had a bunch of discussion about this actually.
Yeah, go ahead. I know that you and Eric were kicking this around in a separate chat while we were trying to still run a speech, so I'll let you guys run with it.
So a couple of things that we came up with. First off, Eric pointed out that the Biden administration is not enforcing the public charge green card restrictions. I don't know if you want to talk more about that, Eric.
I'm not an expert in this, but just know that the Biden administration stopped applying the public charge rule to immigration applications. So that was one reason why people were fearful of this. And so I'll put in the chat the information about that.
And then I know Rent Help MN explicitly states that they do not ask for citizenship or immigration status when you are applying. That question never comes up. So that doesn't matter to this particular program. And then they also say that these funds, the Rent Help MN funds, are not considered income for federal tax purposes and would not impact folks' eligibility for federally funded programs. That's a protection that's built into the law that provides for this emergency rental assistance. So that can be a little different if you have other benefits that aren't federally funded, but this particular one is not supposed to count as income for federal tax purposes. So Julie, I don't know if that clearly and distinctively answered your question. That's something that we haven't necessarily done a deep dive into. So this is the answer that we were able to come up with kind of on the spot, as are a lot of these. So I think it's a great question, but that is the best answer we've got right now. Is it probably the official ruling? There isn't going to be much negative impact on the immigration record from what we can tell. Okay, anonymous. If the tenant has been approved for a Rent Help MN payout, but the landlord denies it, does the payment go to the landlord?
And Eric, I know you've had a lot of sort of high level conversations, and I think the question is actually mistyped. They're saying, does the payment go to the tenant?
Mm-hmm.
Right? That's really what the question is about.
That seems, yeah, I think that makes sense to me.
Right. So again, if the tenant has been approved for Rent Help MN payout, but the landlord denies it, does the payment go to the landlord? It's the question. I think the question means to say, does the payment go to the tenant?
Yeah, I think the landlord denies it, or yeah, doesn't, if the landlord doesn't want to take it. Yeah, I think and we can put the link to the Rent Help MN program guide. I think we shared that last week, but there is a policy in the guidebook around direct payment to tenant, which is allowed under the ERA programs. I'll put a link to that in the chat.
Okay. All right, so then Scott, I believe it's the same Scott from before, Mike.
Yeah, I think we answered that question already. So
yeah.
Let's take Tim's questions.
All right, done.
Let's do them. Yeah.
What should a landlord attorney do if a tenant pretends to have an attorney, in his opinion, as a delaying tactic and will not respond to attempts at communication?
I don't think this is a landlord tenant specific question, really. This is the kind of thing that you should check with the ethics board. So lawyers that are watching, almost every lawyer knows this, but you can contact the state ethics board that oversees attorney licensing and ask a question. You can say, hey, look, this is the situation I've run into. What am I ethically allowed to do? Because there's an ethical consideration that Timothy's brought up here, which is you're not supposed to communicate with a represented party. You're supposed to communicate directly with their attorney. So that's really what this question is about. And so, yeah, I don't think this is a landlord tenant specific question, although tenants might do it, landlords might do it. I know I've certainly dealt with landlords before that said I have an attorney, and it turned out they didn't have an attorney. And he's saying that it sounds like tenants do the same thing. So yeah, I would check with the ethics board on what steps you can take to make sure that you're still able to represent your client.
All right. Mike, does the CARES Act apply to commercial tenancies?
Yeah, I don't think so. We don't spend a lot of time on commercial tenancy questions, but I had a quick glance and I think that it's not covered there. I think it's just about residential tenancies.
And Tim would like to know, will, I assume it's either the or their eviction
Yeah, I think
moratorium
it's the.
be reinstated?
So the eviction moratorium that we originally had in Minnesota was an edict from the governor, really. It was a one-person decision. I mean, the governor filtered it through whatever administrative staff they had, but the governor decided it. Could the governor decide to have another eviction moratorium? Sure, I guess. Maybe it's really hard to predict. I mean, if I would have been guessing, I would have thought that we would have all been vaccinated by now, but that hasn't happened. So who knows whether or not the numbers get so bad that the governor decides, wow, we have to do an eviction moratorium. But I think we have the off-ramp in place. So I think, and this is the state level that I'm talking about here. I think it's very unlikely that the state is going to institute another eviction moratorium during the off-ramp. I think that everybody's going to say, hey, we thought all this through, and so we've got some protections built in place, trying to get back to whatever normal is. At the federal level, I think it's very unlikely to have a CDC type eviction moratorium once again, an edict from administration. However, the federal legislature could decide, let's say that they wipe out the filibuster rules, could both the House and the Senate, if they're controlled by Democrats, decide to have an eviction moratorium put in place? Sure. And that, if we look at the Supreme Court's ruling on the CDC case, they seem to say, if the legislature did this, it'd be okay. But the administration doing it, they weren't authorized to do. So longer answer than he was probably looking for, but I don't think it's likely to see one at the state level, but who knows?
Your crystal ball is not all knowing.
Right.
And then finally, of the last of the Tim questions, basically just want to make an opinion that landlords are victims here and not the problem. I assume that was in response to something you had said.
Well, I don't know if it's something I said or not, but yeah, look, hey, a lot of landlords have not gotten rent for a long time. No question that is not business as usual. That's not what we want to have happen. That's why there's so much money that's been sent from the federal government to try to solve that problem for landlords. And I wish landlords would get paid faster, not only for landlords, but for our clients, tenants as well. It's better for everybody.
Right. And there was an anonymous question that came up for clarifying. Basically, it's if the landlord includes reasoning for non-renewal in October, not related to non-payment of rent, doesn't make a difference. They think that their tenant is only behind by 1 month and that there's speculation that they quit paying for the sake of applying to rent help to avoid displacement by non-renewal.
Yeah, I mean, I guess it's an interesting thought that a shrewd tenant could try to get rent help assistance by not paying their rent and suddenly becoming eligible for rent help MN. Landlord lawyers, for as long as I've been in practice, have encouraged their clients to not say a reason for non-renewals of leases. I've always thought that was maybe not the best approach, because it's one of the things, working on a tenant hotline, I can guarantee people, this is one of the things that makes tenants the most upset, getting a notice to vacate or a non-renewal for no reason. And then they ask the landlord about it, and the landlord just says, I'm not going to answer your question. I don't have to have a reason. It's infuriating to tenants. It's one of the things that makes tenants angriest when they're calling us. And that takes a lot to get to that level of anger from calls that we get from tenants. So it's not exactly business as usual for landlords to name a reason in their non-renewals. They could, and maybe now it makes some more sense to do that. I'm giving you a non-renewal because you have a dog and you're not supposed to, or whatever. That might make a case better for a landlord, yeah.
That's it. We have done it. We have gotten through all of the questions. Well done.
Success. Thank you. Thank you both, Mike and Rachel. Everybody who stayed the extra 4 minutes gets extra credit, and appreciate you all joining us today. Again, just a reminder, and I put the link in the chat for next Wednesday's session, where we'll be joined by Housing Link's research manager, Dan Hilton, to cover some of their research and data analysis on the rental market during the pandemic and the moratorium. So please consider joining us next week. And again, thank you for joining us today, and have a good rest of your day.